You are listening to the IFH Podcast Network. For more amazing filmmaking and screenwriting podcasts, just go to ifhpodcastnetwork.com.
Welcome to Filmmaking Conversations with Damian Swaby. Listen to conversations with award-winning filmmakers, directors from the golden age of television, and creatives from the indie film community who continue to inspire the next generation of filmmakers. And now, over to your host, Damian Swaby.
Today on Filmmaking Conversations, we have an exceptional guest for you. I am joined by the talented Lisa A. Callif, an expert in copyright law. Lisa will share her invaluable insights on a topic every filmmaker needs to understand: navigating the complex world of copyright, fair use, and protecting your creative work. Whether you're an emerging filmmaker or a seasoned professional, it is crucial to protect and safeguard your work from legal pitfalls. Stay tuned as we dive into a detailed discussion on the 1976 Copyright Act, its implications for modern filmmakers, and the importance of protecting your creative work from inception to distribution. Lisa will also touch on international copyright issues and provide practical advice on drafting collaboration agreements, ensuring your projects run smoothly and legally. We'll also discuss the critical aspects of fair use and how the 1976 Copyright Act has shaped the way filmmakers protect their work. We'll also discuss the critical aspects of fair use and how the 1976 Copyright Act has shaped the way filmmakers protect their work. Plus, Lisa will share insights on the automatic copyright protection that creators enjoy today and the importance of registering your work to strengthen your legal standing. Additionally, I will share my experience with Lisa's highly recommended book, Clearance and Copyright, which has been an invaluable resource for me and promises to be for all filmmakers, especially those working on documentaries, in my opinion. Her commitment to empowering creators is truly inspiring. So grab your notepads, filmmakers, because you don't want to miss this informative episode packed with essential knowledge for your creative journey. Filmmaking Conversations, where creativity meets clarity. Lisa, how are you today?
Hi, Damian. I'm good. How are you?
I'm not doing too bad. I've got a bit of a cold, but other than that, okay. I can't complain.
Well, good. And I'll take it easy on you since you have a cold.
Thank you. That is going to be appreciated. It really is. And one of the things I have been able to do over the last few days or a week or so is get through reading this amazing book. You may have heard of it.
I have heard of it. It's a great read.
Clearance and Copyright. I've learned so much. It's helped me so much, and I believe it will help other filmmakers, especially someone like myself who is making a documentary, and I have to think about fair use and what I can use and why and where I can use it. So this book is really valuable to all the listeners. And in the show notes, I'll have links to where you can buy the book, purchase the book, and read the book. It definitely should be part of every filmmaker's book collection, in my opinion. So one of the things that came up with the book that I wanted to question you about is the 1976 Copyright Act. It introduced several pivotal changes to copyright law. In your opinion, what are the most significant implications of these changes for the modern film industry, and how have they shaped the way filmmakers protect their work?
Right. Well, I mean, I think there was a lot of changes, obviously. But I think the things that really impact filmmakers, and especially independent filmmakers and really just independent creators of content, any type of content, is that there's no requirement to register your work prior to you having copyright protection of that work. So if you created something before 1976, you actually had to register it with the Copyright Office, or it fell into the public domain once you published it. So if you published something and it wasn't registered, and also you didn't have a notice on there with the copyright owner, it would go into the public domain. And now, the minute you put pen to paper, the minute you write a script, the minute you shoot a scene in a film, you own that work. So the creator owns it, and they have valid copyright to it, and they don't have to register for copyright protection in order to have that. So I think that's probably the most important, at least in my practice. There's probably other things that impact other people more, and maybe there's music issues but at least for content creators, that idea of like automatic copyright protection is pretty amazing. And then I think the other thing is just that the term is now for life plus 70 years of something you create. There's no requirement to renew it. There's a lot of the formalities have fallen to the wayside and made it a lot easier for someone to protect their work.
When you say life plus 70 years, why do you think the term, or why have they come up with 70 years? Well, why not 100 or why not 150?
Well, I think we call it the Mickey Mouse Law because Disney lobbied. And you're testing my memory. I think it was twice because actually maybe it was just once. I think the initial term was life plus 50. I think, with copyright, we're lawmakers are struggling with the idea of this complete monopoly that one has on the copyright protection on the protection of their work versus a First Amendment right of free speech and someone's ability to comment on and create and even copyright. The purpose of copyright is to progress the arts and sciences and to make it so that people are incentivized to create. So if somebody helps onto the copyright forever and ever, you would never be able to create on that work or embellish it or do something else with it. So there's always been this balancing between how long should somebody be able to protect their work for. And initially it was life plus 50. And then Disney really lobbied pretty hard, and all the motion picture studios lobbied really hard to extend it another 20 years so that Mickey Mouse wouldn't fall into the public domain. Now Mickey Mouse, well, at least the Steamboat Willie version of Mickey Mouse has fallen in the public domain just on January 1st of this year. And so that kind of created a big hullabaloo, but they were not able to extend it past that life plus 70. But I think that was the time that people felt was a reasonable amount of time to hold on to that work and have an exclusive monopoly on it, essentially.
And sometimes what I gather is things or characters falling into public domain can be domestic or international. For example, Robin Hood, the character, basically Hook in the Robin Williams film, couldn't get a certain amount of attention or release in the UK because of the copyright issues around that. Can you explain those copyright issues around that situation?
Yeah, you're testing me, but it is something that we have to advise clients on because just because something's in the public domain in the US doesn't mean it's in the public domain everywhere. The US does have one of the longest terms, but I believe there's a couple of other countries that have even longer terms than we do. And then there's special protections, like the UK has special protections for Peter Pan, and there's just special protections in different countries where when one comes to us and says, we want to do a story based on, the original version of Cinderella or something that was created pre-1928 even. And we say, okay, great, but we have to make sure that it's in the public domain around the world. And if it's not, then we have to take measures to ensure that there's no liability that arises from exploiting that work. But so every country has its own copyright laws, including their own terms. So it becomes complicated. You're like, are you an expert in international copyright law? I'm like, no, I'm not. I don't think anybody is, but we're very good at collaborating and figuring things out with other lawyers in other countries.
And talking about collaboration, for many of the listeners who are independent filmmakers, collaboration is key. So when co-owners in a film project draft an agreement to collaborate, what legal clauses do you recommend they include to address issues like decision-making, profit sharing, and dispute resolution?
Well, I think you just nailed them on the head, those provisions. But yes, I think that, I think people, sometimes collaborators, especially you're writing a script with a friend and you're just writing, you're like, whatever, we'll deal with the business later. It's so important just to write something down, send an email and have the other person agree to it, just so that there's no dispute later. We see things when things have fallen apart, or when one writer thinks they deserve more credit than the other writer, or one writer wants to leave the project but thinks they own it, so they want to give it to the third party, or there's always just a lot of times something happens and the relationship sours or changes. One person's more interested than the other person. So just to write down, and I think write these things down. It doesn't have to be a full legal document. You don't have to hire a lawyer, But to write down, basically, I think important things are credits. How are you guys going to be credited on this? Maybe sometimes somebody like a producer type comes forward with an idea and says, this is the idea and I want you to write it. And maybe that person gets a developed by or created or a story by credit. And then the writer gets a writer credit. Or maybe you're sharing writer credit. And who goes first? Like, talk about these things when things are great and you're creating and you're developing something together. But I think credit, split of compensation, are you guys going to split it equally? Does someone get more? And then what happens if one person's not interested and the other person is? And you don't have to come up with solutions for every single contingency that might occur, but at least coming up with the basics. Like, if it's someone who's like, what, I just got married, I might be having a baby, I might not even want to write anymore. If I drop out, I still want that created by credit, but let's reduce my participation to 20% because I don't want to do it anymore and you're going to sell it. Or, just have those conversations candidly up front to have those things like credit, compensation. What happens if we don't want to do this together? Those are probably the three most important. Compensation would include profit participation. I think those are the most important aspects to cover. There's lots and lots of other details, but if you have those basics down, I think you'll be in better shape than most.
Can you give us an example when people haven't had the basics down and what was the outcome in that situation?
Oh, I have a fun example for you. So I have one example where I had a client, they wrote a script with a co-writer. They had a dispute over who could exploit it, whose it really was. And the one guy who I adore as a client, because he's not that precious about the things that he creates. His viewpoint is very much like, I'll create something else. I didn't know what happened. I'm like, what happened with that script? He goes, I burnt it. I burnt it, and I told him that we're never exploiting it. It's done, and it's in the garbage can. And I was like, wow, good for you. I was like, okay, so that's sort of one. I don't know if that's an extreme. It was sort of like getting to the finish line very quickly. And the other thing we see is hiring lawyers, and negotiating it out and settling it and who owns what. We've also seen I've seen a situation where a writer writes something and then it's about to be shot, or maybe it's already shot, and then someone comes out of the woodwork and they're like, I actually was a co-writer on that and I didn't get credit. And it turns out that that's true. And then at that point, if there's a studio involved, the studio had to step in and pay the guy. Yeah. Just wasn't you don't want to be in that situation. You want to make sure that like there's no skeletons in the closet and everything's sort of buttoned up. And when I say buttoned up, I don't mean you don't have to have 20-page legal agreements, but it's just really having clear understanding of what will happen when things move forward.
So in terms of oral contracts, they're usually something that happens in the early stages of film projects. How often have you had to deal with those, and how bad are they exactly?
Like an early contract that producers put together? God, I rarely have to deal with those. And I think why is because usually then those people are the ones who ends up working out because they talked about it all from the beginning. We usually see it when there's nothing. And I wouldn't say they're bad. I mean, I might be more lenient than others, but it's really, the lawyers make documents look really pretty and we put a lot of language that hopefully the people who are reading it understands everything. We put a lot of clauses in about, choice of law and confidentiality and, this agreement is valid. And we put all these things in there in consideration. But at the end of the day, the key to having an agreement is really just having a meeting of the minds. I like to say there's 4 elements of a contract. And one is that there's people or parties. So there has to be more than one person in a contract. And then there has to be a real agreement where both people know, okay, we're really entering into this agreement. It's not like me telling my kids, I'm going to give you $1 million if you make that shot. He should know I'm joking, right? If he makes a shot, I'm not paying him $1 million. But if I said, I'm going to give you $5 if you make that shot, I think he would say, okay. And he would have a reasonable basis to believe that that's true. And he makes a shot, I have to pay him $5. If I don't, he could sue me. He could sue me for breach of contract. So we had parties, we had a meeting of the minds, we had an agreement and some sort of consideration. And I think that's like another good point to bring, because people often put in like, I'm going to pay you $1 or I'll pay you $10. it's really not valid consideration. Most people, a dollar isn't really what they're doing it for. They're not writing a script for a dollar, but the real consideration is the opportunity to make their script into a movie. And that's really what you're giving them. So if you're saying, like, if you write this script, you're going to be the writer attached to it, you're going to get compensation down the road. Those are the things that are really of value and really the consideration. But that's all you need to make a valid contract, so you have parties, an agreement, consideration, and a meeting of the minds.
For emerging producers, what are the legal pitfalls of them pitching ideas to agents or studio representatives? Because without proper representation or a clear understanding of a copyright law.
Yeah, it's interesting. And I don't think my viewpoint's unique in this, but I just might be more optimistic. But my viewpoint is really, like, if you're an emerging producer and you want to get your work out there, you got to just get it out there. And there are some bad people, and there's some people who might steal your idea or, might move forward on something without you. But most of the people are good people. And if you have a cool idea and you're somebody who they want to work with, they're going to work with you on that. They're not going to try to reinvent the wheel and do it with somebody else. And I think that's the vast majority of people operate in that way. So I think if you're an emerging producer, one of the things I tell people is to create more. If you just come with an idea, I have this great idea of, a man and a woman, they fall in love and then they break up and then they get back together again at the end of the movie. Like, one, that's not copyright protectable at all. It's just an idea. It's something that's been explored many, many, many times in, like, every romantic comedy that we've ever seen. And so that's not protectable. But if you come forth with really, like, character development, if it's a series, you have a Bible of where things are going to go. And, you really have created something that is protected by copyright, because for it to be protected, we talked at the top about the minute you put pen to paper, it's protected. But it does have to have originality in it, and it has to be more than an idea. It has to be expression of an idea. So if you've really fleshed out the characters, if you've fleshed out the storyline, if you've created pitch materials that are video, if you've created some sort of reel for it, if you've done a teaser, the more the better, because that's going to be harder for someone to take from you without your permission. When you're going with just a real thin idea, that's something that, one, maybe a lot of other people have that idea. It may not be protectable at all. So I think for an emerging producer, if you're going out to the world pitching, one, I think the most important thing is to use common sense. I think most people, if you ask them after the fact, like, I knew I shouldn't have trusted that guy, or I knew I trusted that guy. So I think trust your gut and go out there with something substantial that really has a lot of creative expression in it. And I do feel that's the best way to protect yourself. I don't think it's wise to register very early works with the Copyright Office. Because then you have, like, these random things that are actually now public, and you have these incompleted treatments or ideas in the Copyright Office. And you can also register scripts with the WGA here in the US. And that gives you a date. All the WGA registration does is it gives you a date of creation. So if somebody comes up with a similar script later, you can say, hey, look, I created this on this date and I have proof because I registered it with the WGA.
Excellent. The WGA, I've heard of that organization, and I think it's a brilliant idea for people to register with the organization. And it doesn't cost much as well. It's
very inexpensive. It's a digital registry. You just upload it. But again, all it gives you is a date. So it's really, like, if you're getting down to a point of litigation or serious contention where someone has really stolen your script, and you can show, listen, I created this script on June 10th, 2024. And your first draft is a year later, that's going to be very helpful.
And who can give ideas was one of the things I read in the book I found was interesting. For example, if the plumber or a gardener turns around and says to someone, I've got this great idea about a film or a great concept about a film, he or she might not be able to prove that in court, because their reputation and their history isn't in film as a producer or a director or a writer, compared to someone who does have a reputation or a standing in film production who could possibly sue if their idea was taken away.
Yeah, I'm not sure it has so much to do with the status or the profession of the individual, but more about if it is a he said, she said, or a he said, he said, or whatever the roles are. That's always tricky to prove. And then again, if it's just an idea, ideas are not protected by copyright at all, so that would not be protected. But again, like if you are a plumber who has written a script, then obviously you wrote the script. That's very easy to establish. But if somebody just comes by, anyone, even a very established movie producer comes by and says, "I have this great idea," and it's simply an idea, someone else can go and run with that and not give any credit to that person with the idea. And the person with the idea might get pissed off, and if they're a successful movie producer, might say, "Hey, you need to pay me for that." And something might happen, but the risk could be different there. But if it is just an idea, then it's not protected anyway.
So can you provide a detailed explanation of how copyright law applies to fan-made content and the potential legal risk involved?
Yeah, that's a tricky one. I mean, I think that fan-made content is so there's just a lot of layers to it, and I feel like the first one, I think you have to come from I always come from a place where almost always, if it's fan-made content that's really sort of derivative, right? It's like taking a superhero character and putting them in a new outfit or putting them in a new setting. It probably is a copyright infringement. So I think you have to start with, it's likely this is infringing on the underlying intellectual property. But then there's several things that can kind of make it okay. It's a copyright infringement. One is that most studios don't go after fan fiction unless it becomes like a really competitive project, because they see the value of fan fiction and also don't want to destroy the goodwill. Like, these are the people that love these properties, and if they go out and sue everybody, I don't think that helps anybody, right? Especially if they're doing things that aren't creating that much money, or it's a little play that there's someone's doing locally, or they have a website and they just have a bunch of fans. But once someone starts making real money, or it becomes something that really is competitive, like there was litigation over the Harry Potter dictionary. And that happened because someone created a dictionary, but Warner's wanted to create their own dictionary. And that was something that truly was competitive. They were like, you're actually creating like a piece of merchandise that we would create. This isn't really fan fiction. You're just infringing our copyright. So I think once you start really making money, it could become a problem. And sometimes also I just think studios, if it is becoming a moneymaker, but it is something that the studio sees is beneficial to them and the property, they might just come forward and say like, hey, we need to work out an arrangement. Maybe there's money to be had. So I think that although you start from this place of you're infringing, it doesn't necessarily mean don't create the content. The other thing it could be a fair use. It could be a fair use. It could be a parody. You could really have created something new that's very transformative. That's something that would require a deeper legal analysis, but it's a possibility. So there's a lot of ways to make that initial infringement not a problem.
So, and regarding factual realities, which often involve the use of real people's stories or events in film, what are the legal considerations a filmmaker should be aware of to avoid defamation or invasion of privacy claims?
Yeah, I think that the real thing, I feel people get confused between what defamation is and disparagement. And disparagement is really just talking negatively about someone, and that's okay. You can certainly do that, but defamation is making a factual assertion that is false, that is meant to harm the individual. So it's kind of, I don't want to say it's difficult, I think it's pretty easy, but it is a very specific legal standard where you're making a factual statement that is not true and it's intended to harm. So if you don't have that, you really don't have defamation. So I think the key is telling the truth, doing a good job. And if you are saying something that's negative about a person, making sure that you have sufficient corroboration to back up those statements. And that's actually because the ultimate defense to defamation is the truth. So you want to make sure you're telling the truth and you got it right. that's really the ultimate thing. And then the other thing is, really, and I think to get to that place is to find cooperation, find other sources that have said the same thing. You have an interview subject like in your doc, and they say, my neighbor murdered Jane. Yeah. But meanwhile, you don't know Jane. There's no court records of Jane's murder. There's no death certificate. There's nothing. And there, you don't know what happened. You might want to reframe that. It's like, okay, well, we couldn't find anything. And so sometimes we'll advise clients, like, either let's put something on screen that says we couldn't find anything to verify this, or let's couch it as it's his opinion. Like he doesn't know, but he thinks that maybe this is a person who committed the murder. There's lots of ways to solve that issue. But initially, your biggest defense is really being a good journalist and seeking the truth.
Has there ever been a time in your career when you've had to deal with a situation where someone hasn't told the truth and it's come back to bite them?
Well, I think a little differently. In my career, what happens is that not that they're not telling the truth, but there's not sufficient information for us as lawyers to say that's not defamatory. And maybe it's not defamatory. Maybe it is true, but we don't have anything else to base it on except for maybe one person's statement. And that's sort of the tension that we get into with our clients, where they want to tell a story, they make an assertion in their film, but they have nothing else to back it up. And so then we get into a thing, well, we need something else besides this individual who's making the statement, so we know that it's true. And I think, the most difficult area we deal with are really personal stories. When people talk about things that have happened to them, when people talk about, when I was 6, I was molested by my uncle, and then we as lawyers go, well, can you go back and confirm that that's correct? He really was molested when he was 6. It's like horrifying. It's such an awkward and horrible thing. And we really try to work with our filmmakers so that we're not being insensitive, but also doing our job. Because I'm like, people say things. Most people, as I said before, I think most people are good. Most people are telling the truth, but there might be someone who has a vendetta against their uncle and wants their uncle to go down, and is telling the story. And it's like, this is a great opportunity for me to ruin this guy. That's not likely, but it is possible. And so we just have to make sure. So a lot of times we'll say, like, all right, well, has the person told that story before? Like, if the person has a significant other, is this a story that they've told many times before? Does a relative know about it? Like, we try to be sensitive. Like, maybe there's someone else we could talk about to get to the bottom, or at least to get a little bit more cooperation, so that you as a journalist are being responsible in your storytelling. Like, maybe we don't have a definitive, like, yes, this absolutely happened. We don't have video of it. But we've done our due diligence. We've asked enough people and they've corroborated the story.
I see. Responsible. I like that. I'll remember that myself.
Yeah. I think it's good to think that way. Be responsible journalists. Like, that's when you're making a doc, like, and a fictional story based on the truth you should be a good journalist.
And the Creative Commons license offers a spectrum of copyright permissions. How do these licenses interact with traditional copyright law, and what are the potential benefits and drawbacks for filmmakers using Creative Commons material?
I think that the big Creative Commons, for listeners who don't know, those are basically works that people have created that they are essentially putting into the public domain. So they're saying, yes, we've created this, but you, content creator, can use it how you wish. However, there is an asterisk next to that how you wish, because you need to really read the Creative Commons licenses. There's many of them. And I think Creative Commons does a really good job of summarizing what the either restrictions or obligations are of using the license. But some of them require attribution. Some of them say that you can't modify the work. Some of them say, well, if you use this, then your work needs to be a Creative Commons work. So it's just really important to review the contract before you pull something from Creative Commons, is to review. There's like a 1.0, a 2.0, 3.0, 4.0, and they all have different requirements. Some of them have none. Some of them are like, you can use this without restriction. But if there are restrictions, you just need to make sure you know what those are and adhere to those restrictions and obligations.
What type of restrictions could someone face?
Well, usually the most common one are credit obligations. A lot of them have credit obligations. And then there's one license that actually says something along the lines of, if you use your work, the work that you create also needs to be a publicly available work. So if you're expanding on somebody's, like, let's say it's a video, and then you're incorporating your own elements into that video, you can't then claim copyright protection over your new work. You'd have to make that a Creative Commons work as well.
And orphan works, those whose copyright owner is difficult or impossible to locate. I think a lot of indie filmmakers have had that problem. I have myself, that's for sure.
Yes, we deal with this a lot now, and a lot, especially because there's so many photographs that people find from back in the day, anything from 20 years ago to, hundreds of years ago. So, well, maybe not hundreds. It's anything after, I think the year now is 1928. It moves up every year, but anything before 1928 is in the public domain. Like automatically, there's no way that the copyright would have extended long enough. So it was created before 1928. It's in the public domain. Great. It doesn't matter who the copyright holder is, as long as we can show that it was created prior to 1928. If it's after 1928, we can't find the copyright holder. There's something we've been doing recently, which insurance companies have been agreeing to cover, which is, we call it a low risk. And so we ask our clients to do a pretty extensive due diligence search, which would entail doing if it's a photo, it's using photos, a reverse image search on Google, reaching out to any potential copyright holders to see if they own it. Sometimes it's doing a copyright search with a service that does that, but really doing everything an archival researcher can do to find the source and really coming to that dead end. And if we come to the dead end, then we'll opine that it's a low risk and should be covered under the insurance. Like another good example of that is sort of like maybe some of the old television shows. They haven't necessarily fallen in the public domain, but there's been so much corporate shifting and transfer of ownership that people just aren't clear. So they're like, well, we thought ABC owned it. We called ABC and they said they don't own it, but to contact Paramount. And Paramount, we contacted them and they said they don't own it. And then they said to contact this other little company, and we contacted them and they're out of business and nobody's answering the phone and there's no email address and we can't get in contact with them. And there's no other person that this points to. Then we would say, okay, that's a low risk. You've done your due diligence. You followed that string to the end. And now we know that there's nothing at the end of that string. And we also will, with those orphan works or low risk works, will often advise, or maybe always advise, that the client keep a reserve of funds in case that individual or that entity comes forward and says, hey, you didn't license this from us. And then we go, I'm glad you came forward because we've been looking for you and we couldn't find you. And they can prove that they actually are the copyright owner. Then, it's nice to have that reserve so you can pay a reasonable license fee for it.
And is this the same for music as well, which is often vital for a documentary or a feature film?
Yeah, I think the same would go for music. I think we might have I don't know if we'd have more scrutiny. We actually recently had a doc that we cleared, in quotes, a lot of music under low risk because it was international. It was created a very long time ago. It may have been something that had fallen in the public domain, but we couldn't establish that. And we were able to do that. We got comfortable doing that under a low risk too, because it was like all of the contacts just fell short. And then you also can hire with music. Another interesting thing to do is to hire a musicologist who can analyze the notes and really determine whether or not the song is even copyrightable. Sometimes it might be some sort of riff, or it might be people drumming on the street, or it might be something in use. If you have a musicologist go through that, they might say, this actually isn't even copyrightable. These are only, basic chords or whatever it is.
And the book itself, what was the main motivation for writing the book?
Well, it goes way back before my time. So my partner, Michael Donaldson, we have been working together for about 20 years, but he's been practicing law for a lot longer than that. And I don't know exactly when it was. It was probably like in the early 90s that he wrote the first version. And the impetus was, I'm so tired of answering the same questions over and over and over and over again. He's like, I'm just going to write a book. I'm going to put it all in the book and I will refer people to the book. So it was never like I'm going to make money off of this. It's going to be a great marketing tool. It was really I I just don't want to answer those questions anymore. And I remember him telling me, like, I think he rented a house like at a lake, and he just sat outside and he just wrote it out, and he acted as if he was talking to a specific client. Like, this is how I would tell this person how to make their movie, what clearance issues to, be to attend to. And since then, I got involved at the third version. And it's really went from like 100 pages to what it is now, which is 500 pages or so. And it started being used in film schools, really around the US. And then we found out lawyers had it. And once we found out lawyers had it, we were like, oh man, we should really start putting case citations in there, really button this up a little bit so that it really can be used by lawyers. And then we've always had contracts in there, but we had them downloadable and really easy to access. Like, we didn't want to hide the ball with the book. It was like, here's the book. You can download the forms. Like, it's really something you could use to make a first film, a low budget first film, and be in really good shape at the end of the day. We didn't want you to read it and be like, oh, I have to hire a lawyer now. Like, we want you to hire us when you're at your next film. It's a little higher budget that has a line item for legal. But we want this to be a really good tool to get you on your way to make that first film and that first piece of content.
Excellent. So we're on the 5th edition right now. Do you think we'll ever get a 6th edition?
Well, we just came out with the 5th. I think we come out with a new edition it's like 8 to 10 years or so, or maybe 6 years. So I think we'll do a 6th edition, not for a while. It's a lot of work to put that together.
Yeah, I can imagine.
And then you start reading, but we're always getting ready. So if someone comes to us and like, hey, there's a typo on page 35, like we used to have a physical file, which I actually kind of like better, but we would just have like the chapters. So we'd have each chapter and then we just throw a note in. And so when we were ready to really revise it, we have all that information and we can use all of that.
And lastly, before we go, what was your motivation to become an attorney? And what would you say to any young attorney that wants to follow in your footsteps?
Yeah, well, I grew up in Los Angeles around the arts, and I realized at a very young age that I wasn't a singer or a dancer or an actress. And it's really, it's what you do in LA, right? Something in entertainment. And my father was a lawyer. And I think at the age of like 14, I just made a decision. I said, I'm going to be an entertainment lawyer. And I can be around the arts. I can help people. I was very good at school. That kind of came naturally to me. And I had this idea, like I could really help people create things and be a part of the artistic journey, but not be an artist. And that was sort of my path. And then I knew I always wanted to do entertainment because I did want to work with creators. I had no idea what independent film was, to be totally honest. I was like, I knew, I was like, it doesn't really look as nice. It's in smaller theaters. I was like, I don't really know what the legal work is, like what this even means. And I worked in big law for a few years to get that experience. And then after about 4 years, it was time to make the transition. It was very difficult. And I met my current partner, Michael Donaldson. And we had this wonderful kind of strange lunch where I think he planned our entire future together. And he introduced me to this world, and I'm so grateful because I think that my personality is very well suited to do this production type work, which is very collaborative. We're on the beginning end of things. We're helping our clients put things together and get them out in the world. We're working with lots of different people. There's lots of different moving parts, but really our job is, similar to a producer. And then, like I always think, a producer is just someone who has to solve any problem. We're here to just keep the legal ducks in a row and make sure that at the end of the day, when it's time for you to deliver, you are prepared to legally deliver your film. So we're always thinking kind of that big picture of how do we get to the end and what's it going to look like at the end. So I always knew I wanted to be in entertainment. It's a long-winded way to say I always knew I wanted to be an entertainment lawyer. This type of law really came as a surprise to me. I figured I'd represent talent. Like I didn't really know the difference. There's different specializations within entertainment. I think the most prominent lawyer is a talent lawyer, one who represents actors and directors and writers, and that's what I thought I would do. But I think that this type of law really suits my personality much better than being a talent rep. So I'm happy I found it. And I would say, just to younger people out there embarking on this career who want to do entertainment, I think it's like anything else in life, and you just have to be persistent. It took me a very long time to land in this position that I'm in now, but I've been working with Michael for 20 years. We've developed this great practice. We have 16 lawyers that we work with. Wow. It's been really a very rewarding experience, but you got to be tenacious. You got to keep your head up, and you got to be willing to take on other experiences, even if it's not entertainment. Just kind of keep your eye on the prize for the long run.
Lisa, thanks so much for coming on. I really appreciate your time, and I hope to speak to you soon.
Yeah, thank you so much.